Question is the bill be read a second time. The honourable member for Hobart.
Thank you, Madam President. I'd like to acknowledge the member for Murchison and the leading speech on this particular bill, and I want to also congratulate those that have given such a great account of what their particular feelings are, and that debate that you just brought forward from, and I'll say the honourable leader, but it's the honourable member for Derwent, was very much appreciated. I'm going to talk a little about our role, the bill and its merits, the level playing field, the mental health issues, and the choice to marry. But can I acknowledge the people that have lobbied and lobbied very heavily on this particular issue. I think there's no doubt in my mind that anyone who wanted to lobby has lobbied. Madam President, after 20 years in local government, I've weathered many email storms on issues that have polarised the community. Generally, the most hotly debated have been projects involving public art, believe it or not. But those debates pale into insignificance when compared with this debate on same-sex marriage. I'm wondering whether any other honourable member has ever had such an email storm as this. Someone said that maybe the pulp mill debate, but I certainly wasn't around for that. But when I recently conducted a campaign for this seat, little did I know that just 4 months later I would receive no less than 2,244 emails on the topic of same-sex marriage, and that's only up until Monday night, and I think we've probably received another couple of hundred since. But it's fairly obvious from the influx of those emails that the issue of marriage is very highly regarded, and from both sides of the debate. We'll have our opinions as to how well this bill has been drafted. And there have been many observations made as such, but what I personally find hard to accept is the notion that the bill should be thrown out because it has no merit. It's been suggested that the Labor Party has no mandate. Well, regardless of that observation, it is our duty to deal with the bill that's before us, and it's our role to review it and not to meddle with their strategic intent that they have. It's for them to answer to the people for that, and I think that needs to be made clear. The vast majority of the emails I've received from people that are against the bill focus on the perspective of their faith, and they have the right to do that, every right in fact. For we have freedom of religion in this country. Their faith means a lot to them, and it is indeed their way of life. They stress that they are not homophobic, but they have concerns about the lifestyle, which to their mind goes against the tenets and principles of their faith. And I'm sure that that is, for the bulk of those that have been emailing in, that is their feeling. They don't wish to denigrate people. They don't wish to treat people as second-class citizens. It just simply doesn't fit with their faith. We've all received well over 1,100 emails in that regard, some being from people who are members of our community, who have faith in particular but see this bill as a backward step. As their local member, I personally took delivery yesterday of a box of 1,575 letters from Family Voice Australia, which is a group that exists within my constituency and a number of others, no doubt. The letters support the status quo, reiterating the institution of marriage being between a man and a woman, and their concern for children and all of this. Now, while I'm disinclined to agree with their view in this particular case, they have every right to be heard, and that is why I agreed to accept them here at Parliament House. They did not wish to have them tabled as such for certain reasons, but I publicly acknowledge them, and I'm going to actually read their letter. And it's an open letter to marriage, on marriage to Tasmanian legislative councillors. Thank you for the sacrifices you have made to serve our state. Tasmania's upper house plays a critical role in ensuring that our governance reflects the common good and that our state laws are truly reflective of the best interests of our wider community. In view of this, we strongly urge you to reject the push to legalise same-sex marriage in Tasmania by voting against the Same-Sex Marriage Bill 2012, recently passed by the lower house. Like Prime Minister Julia Gillard, we support the time-honoured meaning of marriage as an exclusive lifelong union between a man and a woman, quote unquote. Ms Gillard has affirmed that, quote, in our society, with our heritage, with our traditions, with our history, marriage is a special place and special definition, unquote. That was ABC Radio National on the 18th of November 2010. They go on to say, governments have granted marriage a privileged status not given to other types of relationships for two key reasons. Only true marriage of a man and a woman provides the best environment for raising children, offering stability plus complementary role models, mum and dad. And only true marriage enables the complementary masculine and feminine natures of men and women to benefit each other and the wider society. They go on to say, research shows that true marriage is the most enduring of human sexual relationships. It is more stable than male-female cohabitation and far more stable than homosexual relationships. In general, children raised by their married parents do better than those raised by cohabiting parents, who do better than children raised by same-sex parents. Children brought up in non-marriage contexts have higher rates of physical and mental health problems, child abuse, criminality, drug abuse and poor academic performance. Marriage is under attack across the Western world. Some countries have given in to pressure from the homosexual lobby to allow the same-sex marriage or official registration of same-sex relationships. The result has been a decline in respect for marriage, an increase in fragile male-female cohabitation and more children growing up in fatherless homes. Giving same-sex partnerships the legal recognition of marriage would undermine its unique status, with devastating consequences for children and for society. Under the Australian Constitution, marriage is a Commonwealth responsibility. The meaning of marriage in Australia is the male-female meaning it had when the Constitution came into force in 1901. The Tasmanian Parliament has more pressing Tasmanian matters to address. Trespassing on Commonwealth responsibilities will be likely to cost Tasmanians expensive litigation in the High Court. Please protect children and Tasmania's future by opposing this bill, thus affirming children's needs for both male and female parental role models, and faithful man-woman marriage is the best environment for raising the next generation of Tasmanians. And then there's the signature block. So I wanted to read that out because it's 1,575 people, and I don't think that that they should be ignored by just simply mentioning it. So I don't table it, but I've read that. Many emails take up the alternative viewpoint that as a society we should not discriminate, that legislation should be fair to all, that we are denying our fellow human beings the same right to a genuine and public commitment that others in our community enjoy. I've personally responded to many of these emails. As of all members in this House, I expect as time and stamina have allowed, because I've got to tell you, trying to keep up with it is just amazing. I found myself waking up at 6:30 in the morning, sort of listening to the news and reaching across for the phone just to see what I had to do for the day, and there they would be. 150, 200 new emails, going through them, you know, just ticking them off, putting them in the boxes, you know, having them responded to at various times, certainly doing as the same as the one of the honourable members here mentioned, putting the ones aside that had something new to say, considering those. It's been a task, and if you can appreciate that it has been 2,244, I think I said, and that's been over a period of about 3 weeks. So, Madam President, my position is this, and it's all about a level playing field. While I was brought up in the Gospel Hall tradition, so I have a gene within me that exhibits as an acute sense of fairness. Firstly, in the present society in which we find ourselves here in Australia, we have many and varied faiths, religions and belief systems. The Constitution of Australia promotes a level playing field with respect to faiths and religions. Clause 116 of the Constitution reads, "The Commonwealth shall not make any law for establishing any religion or for imposing any religious observance, or for prohibiting the free exercise of any religion, and no religious test shall be required as a qualification for any office or public trust under the Commonwealth. Now, this is the basic separation of church and state, I guess. To my mind, therefore, it follows that within the Commonwealth, it is important that legislation should not force people to follow the principles or tenets of any particular faith or religion, no matter how much we might be wedded to our faith or religion. It is for the faiths or religions to promote their tenets and principles to the populace, not legislation. It is important we have a level playing field in that regard. I believe the present Commonwealth Marriage Act discriminates by default with respect to its definition of marriage and is therefore marginalising a section of our community. It is forcing people to follow the belief system that is not right for same-gender couples to participate in marriage. It is denying equal treatment of all citizens. That is something that we can put right through the passing of this bill, Madam President. I cast my mind back to the days in the Hobart City Council where we were the first council in Tasmania to develop and to pass a social inclusion policy, which happened to be during my time as Lord Mayor. This policy was considered to be very important in ensuring the marginalised in our community were considered and a proactive approach taken to reduce that marginalisation through various activities, groups and events. It coincided with the social inclusion policy that was being developed by the government and which was finally passed, I believe. The Hobart City Council's definition of social inclusion is as follows, and I quote, "It is a fundamental right of every individual to have the opportunity to participate equally, socially, culturally, economically, physically and politically in society. The exercise of this right benefits everyone and is the fundamental building block for healthy and whole communities. Social exclusion occurs when disadvantages experienced by an individual make it difficult for them to participate in community life. These can include unemployment, low income, low literacy or numeracy, lack of access to services, disability, poor health, mental health issues, discrimination and/or locational disadvantage. At its core," it goes on to say, "social inclusion acknowledges that every person has strengths and skills, and when these are contributed to a community, they add value, enhance resilience and exponentially benefit everyone. It presupposes that a society is less than it could be when parts of the community are excluded. It also acknowledges that all communities have strengths and resources that can be identified and contributed to solutions. At its optimum, social inclusion is about having access to opportunities, options and choices in life, and having the resources and appropriate supports as well as the personal capacity, self-confidence and individual resilience to make the most of them. For an organisation, being socially inclusive is about the deliberate actions taken by that organisation to remove or reduce barriers to inclusion and to create opportunities that facilitate and encourage full participation," unquote. It is said, Madam President, that the mark of a city is the way it deals with the marginalised in its community. I have to say that it is no different for a state. There are many members of our community that are gay, lesbian, bisexual, transgender and intersex who are suffering as a result of being marginalised, and not just with respect to marriage. As a state, we can continue to hide our heads in the sand and stand on our religious convictions while around us people are falling ill and some committing suicide as a result. That would not be our intent, Madam President, of course, but it is happening out there in the community. Just the same as there are people who are severely stressed over heterosexual relationships or through business failure. We try and assist the latter in many ways, but only changes to some of our laws can effectively assist the former. Today we can do something about this, Madam President. We can give people the freedom of choice as to who they wish to commit to for life, which is only fair, given our law is not to establish any religion or impose any religious observance. And I turn to the mental health issues. And I note the Honourable Member for Derwent's comments with regard to the possible financial benefits to this state if indeed this bill were to pass. But I too, like him, feel that that is very much a secondary thing. Yes, there may well be financial benefits, but to me, the passing of this bill is much more about human welfare issues here. I'm told in some of the responses that passing this bill will increase mental health issues. Well, I have to say that I believe the reverse is the case. I point to a response from Dr. Fiona Barlow from the School of Psychology, University of Queensland. Her research outlines a number of matters that are worthy of note. Dr. Barlow is part of a group of doctors known as Doctors and Psychologists for Marriage Equality. The group had produced a fact sheet, All You Need to Know About Same-Sex Marriage, September 2012, and recently sent to me on the 19th of this month. And so that's pretty recent. And there are 5 take-home messages. And it's number 5 that drew my attention. And that is about the social and financial cost of denying marriage to same-sex attracted people in Australia. It's on pages 12 to 13 of this particular report. The take-home message: there is a multi-million-dollar cost to Australia from mental health problems in same-sex attracted people due to discrimination. And I quote in part, "Same-sex marriage bans directly impact upon the occurrence of severely debilitating psychiatric illness among same-sex attracted individuals. Estimates using data from several studies indicates a 250% increase in major anxiety disorders, a nearly 40% increase in mood disorders, such as major depression, and over 40% increase in substance use disorders. This is equivalent to over 4,000 productivity years lost to these illnesses. 4,000 productivity years, or over $260 million within a single year, without including costs associated with treatment or productivity losses for carers." And they give a reference. I want to also read from Psychologists for Marriage Equality submission, and it's a submission to the Senate inquiry into the Marriage Equality Amendment Bill 2012 and the Marriage Amendment Bill 2012 on page 3, Mental Health Statistics in Australia, and the Australian Psychologists Society 2007, and I quote, "The increased rate of psychiatric disturbance among homosexual/bisexual people that can be related to minority stress processes are captured below in the following Australian Bureau of Statistics findings." Now this is the Bureau of Statistics findings, where homosexuals/bisexual people are 4 times more likely to have ever been homeless, 12%, that is 12% homosexual, bisexual, versus 2.9% heterosexual. Twice as likely to have no contact with family or no family to rely on for serious problems, 11.8% versus 5.9%. More likely to be a current cigarette smoker, 35.7% versus 22%. More likely to have had a chronic condition in the last 12 months, 51.3% versus 46.9%. Twice as likely to have a very high level of psychological distress, 18.2% versus 9.2%. That is double nearly. Almost 3 times as likely to have had suicidal thoughts, 34.7% versus 12.9%. 5 times as likely to have had suicidal plans, 17.1% versus 3.7%. 4 times as likely to have attempted suicide, 12.6% versus 3.1%. Anecdotal evidence suggests that these rates, particularly suicidal ideation and suicidal attempts, are much higher in rural and remote areas where the effects of social isolation and stigmatisation are often amplified. Additionally, although homosexual, bisexual people may be considered an at-risk group due to higher levels of depression, this is currently not reflected in national health priorities. So, Madam President, after being confronted with that report, It's my belief that we must look at the merits of this bill in terms of its fairness to all in the community. In the civil marriage ceremony, there are vows that relate to two people committing themselves to each other to the exclusion of all others, with the ultimate legal relationship being formed. For those with faith, they have various vows included that express the spiritual aspect of such a bond, with some belief systems having different vows to others in that regard. Do we say to those faiths or religions that their vows can't be different? No, we don't. So why does legislation stop a significant number of people in our community from committing to each other? Don't they have a choice? To my mind, marriage has to be primarily about the mind. You take the mind away and you have no commitment. You take the sexual organs away, in whole or in part, which can sometimes happen through disability or accident or by chance of birth, and commitment is still possible. It's as simple as that. Commitment is not about gender. There are probably people who have a disability and may not be able to make love in the normal way, but are heterosexual couples. Do we say to them, I'm sorry, but you can't participate in marriage? No, we don't. There are couples who simply can't have children for various biological reasons. Do we say to them they can't be married? No, we don't. Do we say to people of the same gender that they can't participate in marriage simply because they are of the same gender? Yes, we do. What is fair about that? Some people are hermaphroditic or intersex, having been born with both sexes, through no action of their own. How do we deal with them under the present Marriage Act? They didn't ask to be this way. It's an uncaring and discriminatory society that stands on its collective high horse and says because you cannot form a traditional nuclear family, we won't recognise your capacity for commitment. As I said earlier, the Commonwealth Marriage Act is by default discriminatory and it must be addressed. I guess until a gene is found, there will be those in our community that will find it hard to appreciate the fact that homosexual orientations exist. They feel that our gay, lesbian, bisexual, transgender, intersex community are choosing that role play. It is simply not the case, as many have been together for decades and are raising children just the same as traditional family units. All I can say is they must have great stamina if they're acting it out. They are real people with real feelings and they need to be treated fairly. There is the argument put forward that it will change marriage forever. Well, to my mind, in terms of sanctity or commitment, marriage is what each couple wish it to be. If this bill were to pass, it would change absolutely nothing with regard to the level of sanctity that couples place on their marriage. How can it? Nothing will change the way I feel about my wife Margaret of 40 years, regardless of how many same-gender marriages there are. No one can take away that commitment that we have. The majority of those who emailed in the against category were concerned it will affect children. The bill only deals with children as an aspect of settlement in divorce proceedings and maintenance issues for the most part, as far as I read it. It's not the same as the Commonwealth Marriage Act in that regard. Further to that, I believe the bill simply doesn't bestow any further rights on same-sex married couples over those in a registered relationship under the Tasmanian Relationships Act with respect to children. It simply doesn't do it. And so I just think we need to think about that. This is not about children. It needs to be noted that same-gender people can apply to adopt now with certain relationship provisos. They can also apply to foster now and will soon be able to have legal surrogacy arrangements. In fact, some have surrogate children already. So this bill won't change anything in that regard. And I think it's a very important point that needs to be made. Now, the issue of whether ministers of religion can be prosecuted for not conducting a same-gender marriage has been dealt with. Clearly, they would need to be registered to conduct such a marriage. If they don't register, they can't be prosecuted for refusing to do so. I believe the various faiths and religions and their premises can be protected, given the correspondence received from the Anti-Discrimination Commissioner for Tasmania, Ms Robin Banks. And I want to read from it. When I find it. Here it is. Marriage Equality, the Same-Sex Marriage Bill 2012, Tasmania. I write to set out my views on the impact of the Tasmanian Same-Sex Marriage Bill 2012, called the Bill, and its interaction with the Anti-Discrimination Act 1998, Tasmania. It's a matter of some concern to me that people, including people in high public office, assert that the definition under the Marriage Act 1961, Commonwealth, the Marriage Act, of marriage as being the union of a man and a woman to the exclusion of all others voluntarily entered into for life is not discriminatory. This is not correct in the sense of the clear meaning of discrimination and undermines the understanding held in the community of discrimination. While it may be accurate to say that this requirement is not unlawful discrimination, that is quite different from saying it is not discrimination. Discrimination is different treatment. It is clear that the Marriage Act treats heterosexual adult couples differently from other adult couples, because those other couples are excluded from marriage under the federal law. Marriage is a social and legal institution that is clearly valued by many in the community, and to exclude other than heterosexual couples from it is less favourable treatment of those couples on the basis of their sexual orientation. The tabling of the Same-Sex Marriage Bill 2012 provides an opportunity to ensure that this form of discrimination is no longer lawful in Tasmania. It does not seek to interfere with the provisions of marriage to heterosexual couples under the Marriage Act. Passage of the bill will ensure that couples in Tasmania, irrespective of their sexual orientation, are able to have their relationship solemnised as marriage either under state or federal law. Both the Marriage Act and the bill recognise marriage as the consensual union of two people to the exclusion of all others, voluntarily entered into for life. As such, the bill is complementary legislation that ensures the discriminatory effect of that federal law is overcome in Tasmania to the extent that it is constitutionally possible. In this way, its application to people in Tasmania is similar to that of the Anti-Discrimination Act 1998, which operates to make certain forms of conduct unlawful if they occur in Tasmania, but does not apply to conduct by the Commonwealth Government. The bill provides an appropriate balancing of the inherent rights of religious freedom with the right to equality and freedom against discrimination on the basis of personal characteristics. All three of these internationally recognised human rights are found in the International Covenant on Civil and Political Rights, the ICCPR, to which Australia is a party. What are those three? The right to equality is found in Article 2. The right of freedom of thought, conscience and religion is found in Article 18.1. And the right to freedom from discrimination is found in Article 26. The Same-Sex Marriage Bill achieves this balance of rights and freedoms by providing access to the right to marriage, also recognised in international law, for those excluded by the Marriage Act, while not imposing requirements on religions in respect of marriages under the enacted bill. The bill does not require a religious minister or other faith equivalent to register as an authorised celebrant under the bill. Where a religious minister or other faith equivalent is registered to perform marriages under the Marriage Act, but not registered as an authorised celebrant under the enacted bill, their refusal to perform a marriage under the enacted bill could not be held to be unlawfully discriminatory, because Section 24 of the Anti-Discrimination Act 1998, Tasmania, has an exception for discrimination that, quote unquote, is reasonably necessary to comply with any law of this state, unquote. If religious minister or other faith equivalent is not registered, the refusal is reasonably necessary to comply with the enacted bill, which permits only authorised celebrants to solemnise marriages under the bill. This provides for the proper respect to be accorded to the right of freedom of thought, conscience and religion, found in the ICCPR. Now, and this is an important part. The question has arisen as to whether or not a couple seeking to be married under the enacted bill could allege discrimination if a faith refused to permit that marriage to take place in a place of that faith's worship, such as a church, mosque or religious meeting house. Such a refusal would not, in my view, be in breach of the Anti-Discrimination Act 1998, Tasmania, or any applicable federal anti-discrimination laws, so long as the faith required people seeking to be married in that place to have that marriage solemnised by a minister or other faith equivalent of that faith. Such a requirement would be considered under the Anti-Discrimination Act 1998 Tasmania in terms of whether or not it constituted indirect discrimination, which prohibits conditions, rules or requirements that cause disadvantage to people on the basis of a protected attribute where the rule, condition or requirement is unreasonable in the circumstances. If a faith has a requirement that people wishing to be married in a place of worship of that faith, such a requirement does have the very real potential to disadvantage, on the basis of their sexual orientation, people seeking to be married under the enacted bill where faiths do not have ministers or other faith equivalents who are authorised celebrants. However, as noted above, for such a requirement to be unlawful discrimination, it would need not only to cause such a disadvantage, but also to be unreasonable in the circumstances. Now, I won't go through the rest of the letter, Madam President, but that gives the comfort, I think, that we need, that there is not likely to be discrimination experienced by the churches, and I think that is very important because we do have, sorry, not by the churches, on the churches, because we do have freedom of religion, and it's important that that freedom continues. It is interesting to me, Madam President, that the people who seem to be most passionate for the legislation and the ones that caught my eye were the parents with gay children. They know their children and they know that they are human beings who simply want to love and be loved by that significant other in their lives. Fairness would dictate that we need to ensure this happens for them. Some will argue that even if this bill is passed, it won't be equity because it is same-sex marriage. It is not under the same bill as heterosexual marriage, which indeed will be the case. But same-sex couples aren't concerned about that because it'll remove the entrenched discrimination. It is symbolically marriage and that is fair, and that is what they seek. It is within our power not to discriminate. Sure, there will be the opportunity for a challenge, but by whom I am not sure. At what cost, we don't know, as there have been varying estimates thrown about, and I guess it depends on the silk that you employ. Some are pretty expensive. Yeah. But at the end of the day, at what cost do we balk at removing discrimination, Madam President? Madam President, to recap, what we have before us today is a bill that recognises the need for a level playing field and that it needs to be civil, not faith-based. Not that I have anything against faiths. I have a faith of my own. In order to successfully deal with the very diverse nature of our community and the belief systems within it. That is fair under the circumstances, especially as Clause 116 of the Australian Constitution tells us the law needs to be that way. It needs to be that way regardless of your faith or mine or anyone else's, as the case may be. People should be treated equally with a generosity of spirit. It's for them to deal with any spiritual aspects if they so wish, not for legislation to enforce it. I wish to end by reading from a number of documents. Firstly, TASCOS, Tony Reedy. Same-sex marriage bill 2012, improving social inclusion. Major step towards equality and social inclusion, a fundamental right for all Tasmanians, equal treatment under the law. The bill addresses a legal anomaly. It ends exclusion of a group of Tasmanians from a legal institution. Ends social inclusion of same-sex couples, their marginalisation from mainstream society, their targeting for discrimination and the emotional burden and stigma that accompanies all of these exclusions. The bill does not harm others in recognising the rights of same-sex couples. No one's rights or relationship are threatened. Benefits for couples are tangible. strengthening through according same legal rights and social recognition, allowing couples to celebrate their commitment, and providing same-sex parents and their children with security and legitimacy. Benefits for Tasmania and beyond. Recognised for tolerance and equality, addressing past wrongs, and secures our place in an international cohort that includes some of the world's strongest defenders of human rights. It'll make Tasmania a better place, strengthening it, not weakening it. That's the Tasmanian Council on Social Services. Sorry, I didn't spell that out. I wish to read a letter from the Tasmanian Association of Community Legal Centres. Marriage equality. The Tasmanian Same-Sex Marriage Bill 2012 is an opportunity to remove one of the last bastions of legislative discrimination on the grounds of sexual orientation. It is also a chance for Tasmania to lead the rest of Australia on an issue of inclusiveness and at the same time right a historical wrong, which saw Tasmania take so long to abolish the criminalisation of consensual sex between men. On behalf of a future Tasmania in which discrimination is abolished, injustice removed and equality endorsed, we encourage you to support the Same-Sex Marriage Bill. The Tasmanian Association of Community Legal Centres, that's TACLC, is an incorporated network representing the 8 community legal centres in Tasmania. Our member centres provide advice, representation and legal education services to thousands of Tasmanians every year. We also advocate for law reform on a range of public interest matters aimed at reducing discrimination, protecting and promoting human rights and improving the lives of Tasmanians. TACLC strongly believes in marriage equality. The continued differentiation of same-sex and different-sex relationships is nothing more than discrimination. Excluding couples from marriage on the grounds of sexual orientation reinforces discrimination on the grounds of sexual orientation, sends a message to the community that the ability of same-sex couples to commit to one another does not meet the standards commonly associated with marriage, and excludes same-sex couples and their families from belonging to one of society's most important institutions. To reinforce our case for marriage equality, we draw your attention to a position paper issued yesterday, and this was sent on the 19th of September, so this is the 20th of September, by the Australian Human Rights Commission, in which it lays out why marriage equality matters from a human rights perspective. The paper is attached, but I don't intend to read from that. We have analysed the Commonwealth of Australia Constitution Act 1901, the Marriage Act 1961, Commonwealth, the Commonwealth Act, and the proposed Same-Sex Marriage Bill Tasmania, the Tasmanian Bill. We have also considered the legal opinions of Geoffrey Lindell, Dan Meager, Neville Rochow, Michael Stokes and Professor George Williams, as well as a recent legal opinion provided by Associate Professor of Law at Melbourne University, Chris Walker, which backs the opinion of Professor Williams. Having regard to all of these documents, it is our considered view that the Tasmanian Bill is not inconsistent for the purposes of Section 109 of the Constitution with the Commonwealth Act. In our view, whilst the Commonwealth Act covers the field of marriage between a man and a woman to the exclusion of all others, it does not seek to cover the field of same-sex marriage in Tasmania or other states. Expressed in another way, if the Commonwealth Act had intended to cover the field of both different sex and same-sex marriage at both the Commonwealth and state level, it would have been so amended. While some commentators have asserted that the concept of marriage is eternal and unchanging, the evidence suggests otherwise, with an evolution over the years that it's continually adapted to meet the community's evolving values. For example, all Australian states and territories formerly provided that a married woman forfeited all her legal rights to her husband and was considered his property, whilst for many years marriage between Aborigines and whites was prohibited, and marriages between Protestants and Catholics were frowned upon. The High Court, if required, would need to consider whether the term marriage for the purposes of the Constitution should be interpreted as meaning what it meant in 1901, or whether the term should be interpreted in a modern context in light of the community's evolving values. Whilst there is no High Court authority directly on point, Justice McHugh, a former High Court judge, noted in the case of Rewackham that arguably marriage now means, or in the near future may mean, a voluntary union for life between two people to the exclusion of others. The full court of the Family Court also observed that, and I quote, "It seems to be inconsistent with the approach of the High Court to the interpretation of other heads of Commonwealth power to place marriage in a special category, frozen in time to 1901. We therefore approach the matter on the basis that it is within the power of Parliament to regulate marriages within Australia that are outside the monogamistic Christian tradition. As it stands, it is simply not known what the High Court would find if required to consider the validity of a Tasmanian same-sex marriage act, and I think we've heard today that that is definitely the case. It is also uncertain if there would be a High Court challenge and who could take it. However, what is not in dispute is that as a member of the Legislative Council, you have the opportunity to stamp out legally entrenched discrimination against same-sex couples and to be a part of an historic movement in which Tasmania removed once and for all the shackles of its past to reveal a future based not on discrimination and prejudice, but on love. We urge you to support this bill. Now, we know that this bill doesn't deal with love, but we also know that marriage itself is based on love, and same-sex marriage will be as well. A couple of emails and then I'll finish. I read from Liberty and Megan. Dear member of the Tasmanian Upper House, we've been together for 7 years in November. In that whole time we've lived with each other monogamously, joyfully and completely. In nearly 7 years we've survived so much as a couple and grown more in love. We have supported each other side by side, I think it means, through, and this is what they've been through, 3 moves. Moving my beloved mum-in-law a number of times, deaths of grandparents and transitions into nursing homes of relatives, the tragic accident overseas that killed our niece and seriously injured our sister-in-law and our other little niece, loss of cherished pets, caring roles, voluntary work, and other at times, 3 major surgeries, myriad doctors and specialist appointments, bank account openings, joys, heartbreaks, traumas, abuse recovery, calling for each other and on each other's behalves to schedule appointments, pet adoptions for kids, successes, failures, hopes, dreams, holidays, sharing our pasts, living our presents and looking forward to a future together forever. The above is just the tip of the iceberg descriptor of our journey. If this is not what a marriage looks like, then what on earth is it? Our hearts are breaking that we are not equal before the law. We've attended several weddings of our heterosexual peers and friends, and we yearn for the day that our own previous commitment ceremony of nearly 6 years ago is recognised as an equal marriage before our peers and the law, and is named as a marriage. And I won't finish the rest because it goes on. And perhaps my final one or two here we've got from a parent, Arthur. I love both my children equally and I want them to be treated equally. This is a matter of basic human dignity. A person's fundamental rights, including the right to marry, should not be affected by their sexual orientation. How can I tell my son that he has less rights than my daughter has? Could you tell your own child this? I cannot justify this. Society is stronger when couples make vows to each other and support each other. I want this for my gay son. Religions can decide who they want to marry, but it's not okay for the state to discriminate. It's time to understand the state cannot be in the business of discrimination. The state must introduce civil marriage for all citizens. And I'll stop there because I think I've gone on long enough. Freedom of choice is important, Madam President. It is the only fair thing to do, just as freedom of religion is important. These are the rights of every citizen in Australia. Passing this bill will provide that level playing field with respect to people having the right to that lifelong commitment. Life needs to be fair. It probably won't be for me after today, because having been brought up in the traditions that I've been brought up in, I'm sure there'll be some acquaintances that will simply find it too hard to rationalise the way I think about fairness. Mind you, others may thank me. Who knows? I'd hope we can still converse and enjoy each other's company either way. Whatever I have to go through, Madam President, it can't possibly match the pain and trauma that many have suffered from simply existing as someone in our gay, lesbian, bisexual, transgender and intersex community. And I believe a majority in my electorate support the passing of this bill. I've just been through an election and I can tell you I've pounded the streets and I've knocked on the doors, and many, many people have told me that this needs to change. I support the bill and I look forward to tidying up some of the minor amendments needed should it reach the committee stage, and I urge the honourable members to move in that direction. Thank you.
Question is the bill be read a second time?